It's Rick Harmon. I'm your powers and authority guy, and you're thinking, what the heck is that? Well, when you come to us with a matter and you want to borrow on your probate estate or trust, we're going to look to see if your name is on the paperwork. Is it your name? Is it someone else's name? Is it your name along with somebody else? We want to know about your ability to use a particular property as the collateral for a loan. We want to know if it's okay for you to do that. Is there any reason why you should be empowered to do that? Typically, here's what happens. With a probate estate, there are a couple of documents that are established. One is you're named by the court to be the executor or administrator. The executor is the person who executes for the wishes of a decedent who's left a will behind. And an administrator is basically the same job, but there may not be a will, but you're not the person who is named in a will. There's going to be two documents that'll be controlling. One is an order from the court that establishes you as being the executor administrator. But the document that we're going to look at first is a form, one-page form from the court, California property, called a probate letters of testamentary or probate letters of administration. And that document is going to be the controlling document we're going to look at. We're going to look, about halfway down the document. It's going to show whether the box is checked off that you have full authority or limited authority. If you have full authority, it's going to be easier for you to get any kind of a loan or do a transaction. What's required title insurance, basically anything that you're going to do with us, or if you're going to sell the property. And that allows you to do certain things without having to get court approval if everybody's into agreement. A standard noticing period is allowed, a couple weeks, 15 calendar days, and then you can go forward if nobody disagrees. You don't have to have an affirmative, meaning you don't have to have a written consent, although it's nice to do, and you can save yourself a few days' time. Now, if you don't have full authority, you're going to presume to have limited authority, or if somebody doesn't agree with doing this and they object by sending a note to the judge or to the court or whatever, or just notifying your attorney, what's going to happen is this will require that you go and get a court order, meaning going before a judge. This is going to take time too, because it typically takes anywhere from a month or two to get a court date, to have a hearing, and your attorney state your case for why you need to do this loan or sell the property or take some other particular action. And that's a pretty straightforward thing to do, but it is a tedious process. There is some additional expense by attorneys. And of course, we can't close your loan until you have that. The controlling document we're going to get back from that is going to be called a court order, and it's going to have a purple stamp, meaning it's certified. Now, if your family has established a trust, and we can establish how you became the person in charge of that trust, and that you are a relative, we have a copy of the trust, and you're named in the trust as a successor trustee, and we see your powers are to borrow against, or also we say encumber the property using the equity. That's a pretty straightforward thing to do, as long as you don't live in the property. And if the trust also establishes that the person who originally was the settlor is now deceased, of course, we're going to need to have a death certificate. Even same with the probate, we want to see a death certificate so we can confirm and be able to connect the dots. It's most important for our title insurance company to be able to see that. Now, with that in hand, that's going to give us a good start to know whether we can make a loan or not, at least as to the powers and authority part of the type of a transaction that's intended. If you don't have this, we may find that there are workaround ways, or that something has a situation where somebody is supposed to take action but hasn't taken action. We can have a consultation with you or the attorney and discuss how we remedy that. We're not in the business of solving your legal matters or your tax matters. We're in the business of advising you how to get financing and how to make the loan to the estate or to this trust. But what we can do is we can actually give you a vision of how you might go about doing that and guide the attorney through with the paperwork, because odds are the attorney has had a limited number of opportunities to fix that themselves, and we're happy to help. And that's why we're here. For fun and for free, whether we work with you in completing a loan or just have this conversation, we're willing to do that as long as you're providing us the documentation we request on the front end. And that's free.